welcome to Arbitration Acumen, a podcast from Bracewell's International Arbitration Group that connects in-house counsel and arbitration practitioners with industry experts, institutional insiders, and top arbitrators from around the globe to share their views on key issues in arbitration today. You can reach out to any of today's speakers by emailing arbitrationacumen@bracewell.com. And we hope you enjoy this episode of Arbitration Acumen.
All right, welcome back to the next episode of Arbitration Acumen, in which we'll discuss the respondent's perspective on mass arbitration with my Bracewell partner, Brian Patterson, as the fifth and final installment of a multi-part mini-series we've been doing on mass arbitration, which has been really interesting. In the first three episodes, which you can find on Bracewell's website, as well as on various podcast platforms, representatives from the CPR, JAMS, and the AAA discussed their respective procedures for handling mass arbitrations. And in the last episode, Mike Hartmere, who's the CEO of the HQ firm, gave us the claimant's perspective on the subject. In this final episode, Brian will enlighten us about the respondent's approach to mass arbitration, which is a great way to close the topic out. Let me begin by making some personal introductions. I'm JP Duffy. I'm an international arbitration partner at Bracewell based in New York that acts as both counsel and arbitrator in arbitration seated around the world under a variety of governing laws and arbitral rules. I'm qualified in New York, England, and Wales, and the DIFC courts in Dubai, where I used to live and practice. With us today is my partner, Brian Patterson. Brian is a board-certified labor and employment attorney and a native Houstonian, and he has more than 20 years of experience with a primary focus on litigation. His practice centers on non-competes and other restrictive covenants, executive disputes and terminations, and FLSA collective actions. Brian primarily represents employers in the energy and infrastructure sectors. And over the past 3 years, he's tried 27 arbitrations to final hearing. So we're really fortunate to have Brian with us today and really look forward to hearing his insight. So as you can tell, Brian can provide interesting insight on this topic from the respondent company perspective. So welcome, Brian, and thanks for joining us today.
Thank you, JP. Great to be here.
Great. Let's start by talking about mass arbitration generally. I'd like to begin by asking you a question that I've asked all the other guests. And while it sounds like a simple one, the answers have all been slightly different, which has been pretty interesting in and of itself. So what do you consider to be mass arbitration?
I would say that mass arbitrations are the coordinated filing of a large number of individual arbitration demands that assert similar claims against the same company, typically by the same law firm that are coordinated and all filed at right around the same time.
And what are some examples of context in which it arises?
I'm a labor and employment lawyer, and for my clients, it typically arises in one or two situations. It's either Fair Labor Standards Act cases that are filed as collective actions, and the employees are subject to arbitration agreements, and arbitration is then compelled, and those claims are litigated individually. Or you see it from a misclassification perspective. So like the DoorDash case is a great example where employers in the gig economy engage a number of contractors to perform services. Those contractors claim that they've been misclassified as employees and then sue for violations of either the Fair Labor Standards Act or state wage and hour laws. And they can bring those claims either collectively under the Fair Labor Standards Act or sometimes, depending on the state law, as class actions or Rule 23 cases.
Right. Now, you're talking about a couple of different statutory contexts there. I guess the key thing to keep in mind is in both those situations, there would be a contract with the employer that contains an arbitration clause, right?
Exactly. In both of those situations, there would obviously have to be an arbitration agreement in place, either with the contractors who've sued or the employees who've sued under those various statutes. I think that's typically the situation in which I advise employers to enter into arbitration agreements, is to avoid the class or collective claims. But there's obviously been some issues with that over the past few years where plaintiffs' law firms have taken advantage of the economics of the situations or the economics that situation creates.
Yeah, we're definitely going to get into that because that really is, for someone like me who drafts a lot of arbitration clauses, that's really been the primary consideration that clients have raised when they've been trying to navigate some of this. But you touched on, this notion of trying to avoid traditional class action litigation. entering into these things for the purpose of doing that. How does mass arbitration differ from traditional class action litigation?
Well, I can tell you from my experience representing employers primarily in the energy and the infrastructure spaces, the issue that went through the energy space over the past probably 10 years is that the payment of day rates. And the payment of day rates is typically a violation of Fair Labor Standards Act. It was prevalent throughout the industry. And the plaintiffs' bar kind of marched through the industry, suing the majors first, and then the smaller players, then midstream, and then the other service providers. And what happens in a Fair Labor Standards Act case is they file a case with one or two claimants, and then a class notice goes out to all of the other putative class members. Once the class is formed and there's a significant number of people who are involved, the economics get to such where the risk of losing that case, where all your eggs are in one basket, is so significant that it creates immense settlement pressure on the employers. And so to avoid that, they've implemented class action waivers and arbitration agreements with their employees and with their contractors so that the numbers typically, they have to arbitrate them on an individual basis. And so it drives down the participation in those types of lawsuits. And it turns the economics in favor of the employers, where if they choose to, they can at least litigate the merits of the case. And if they lose, it's not catastrophic at that point.
Right. So that's that really is the primary difference, right? It's that in a class action, you have one trial that determines everything for the entire class. Whereas with our mass arbitration, each individual claim remains an individual claim that's tested on its own merits. Right. I think that for me is probably the biggest difference. Now, how does the discovery aspect calculate into that too for you?
The discovery aspect, that doesn't play near as big a role in it to me as is limiting the number of claims brought against the employer. Now, the discovery if let's say you have 100 putative class members who've signed up to join the case, who will also, ultimately bring individual arbitrations. The discovery, I think, in the arbitrations can actually be more significant or more costly, and it's less efficient than litigating those claims as a collective action, in federal court. For example, I've represented an employer who rebuilt the power infrastructure in Puerto Rico, had a Fair Labor Standards Act in Puerto Rico state law wage and hour claims brought against it. We compelled it to arbitration. Through those individual arbitrations, the claimants were able to take multiple depositions of many of my witnesses, where if we had been in federal court and those claims had been litigated as a collective action, likely that those witnesses would have been limited to one deposition. If you elect to arbitrate on an individual basis, the discovery can actually be less efficient than litigating them as a class or a collective.
Interesting. Now, in that example that you just gave, was it, for instance, like the same witness on your side being deposed multiple times by different claimants?
Yes, I had the corporate representative for the companies who's being sued was deposed. It was more than 20 times.
Wow, interesting. Okay, well, that's certainly something when I start to get some of the other administrators back on to talk about their claims administration process, that's something I'm going to ask them about, because that's a really interesting situation. I think that's one now that they would say, hopefully they could avoid, but interesting situation there. Now, let's take a slight turn here, because you raised it earlier. You talked about the economics of it. That's obviously a really important consideration for respondents. And I know just from the strategic clause drafting phase, that's something that we try with clients to manage and to think through and to plan for. What do you see as the current state of play in terms of the economic pressure that can get put on respondents with a mass arbitration claim?
I think it's primarily dictated by the number of potential claims or claimants that there's going to be. And so if you're a large employer and engage a significant number of employees or contractors, there's obviously the threat that they could bring some kind of class or collective action against you. And the larger the numbers are, the more expensive the mass arbitration is going to be. And then the more leverage they would have in a class or collective action if there are no arbitration agreements in place. And as those numbers go down, it might make more sense in some instances to have arbitration agreements in place that limit the number of participants and then drive down the overall value of the claims. And in those instances, the cost associated with arbitration obviously would be less too. When you're dealing with, north of 1,000, that's when you've really got to pay attention to the clauses, the rules that you apply, the fees that are charged for these mass arbitrations, and then take into account the types of claims you're most likely to face from that number of individuals.
Now, have you dealt with a claim or a mass arbitration claim where there's been in excess of 1,000 claimants?
I have not. No, fortunately, my clients have not faced that yet. It's primarily been in the Fair Labor Standards Act cases where the numbers are in the low hundreds.
Okay, that's interesting because I think, even numbers in the low hundreds, you could, at least under previous rule iterations, that could put a lot of economic pressure at the filing fee stage on a lot of respondents. How have you seen that evolve over time in terms of the economics and the fees?
I think it was in 2024 when JAMS and the AAA, changed their fee structure. And, prior to that, it's interesting in that if the value of the claims was low, that actually, increased the settlement leverage because you could settle these cases out for, less than what the fees would be or something equivalent to it. But if the value of the claims was high, then the economics of arbitration still might work or still might not create a lot of settlement pressure on employers. So for instance, if you have employers who are engaging people, they're high wage earners and they're working 100 hours a week on an oil and gas project and they're highly compensated, the damages that flow from misclassifying them or paying them incorrectly are significant. And so you still might elect to individually arbitrate those cases, and the economic pressure created by the filing of all those arbitrations still isn't enough to drive settlement. Conversely, if you have a number of low-wage workers who are working a low number of hours in a given week and the value of their overtime claims is low, well, then the filing of all these arbitrations creates a lot of pressure to settle because the value of those individual claims is low. The employer doesn't want to, spend more on arbitration than it would cost to just pay out and settle the claims. So that's the situation I've seen my clients face and the economics that drive their decision-making process.
Interesting. Now, let's say you've got one of those situations where it is higher, there are higher value claims at issue. There's a pretty high number of claimants. Obviously, as we said before, one of the things that sets mass arbitration apart from class action litigation is the fact that each one has to proceed on its own merits and theoretically could go through to an individual arbitration. How do respondents investigate and track those individual cases? Like you as the lawyer, when you start to see these come in, how do you go about parsing through them and saying okay, I've got to figure out which of these are meritorious, which ones can I try and get rid of early? Talk to us a bit about that process.
Typically, in the situation in which a mass arbitration is brought against an employer, it's challenging a specific employment practice. It's either a pay practice or a classification decision where there are going to be a common set of facts that are applicable to all of the claimants. And the central issue in the case is going to be the same or close to the same for all of the claimants. And so typically you evaluate the pay practice at issue or the classification determination at issue. And that can drive your thinking on whether you're going to settle, whether you're going to fight, whether there are significant differences between particular claimants, and maybe you should settle some and then fight the others. That's typically how, when I'm brought a situation like that, how I would begin to evaluate it.
Now, I would imagine some of that can get sussed out too at a mediation phase. How do you feel about a mandatory mediation process the mandatory mediation process that some institutions have introduced?
I have mixed feelings on it. Sometimes the mediation process, if you're compelled to mediate them individually, that can drive the cost up and the time up as well. And if you're not going to settle one, you're not going to settle the others in most instances. And so it's kind of an exercise in futility. And it can be leveraged by plaintiff's counsel to kind of drive the fees and the costs associated with the arbitrations. So I don't like them in that instance. The other issue that I find is in Fair Labor Standards Act cases that are brought on a collective basis, it can be difficult for plaintiffs' counsel to negotiate as the collective because it does require each individual claimant to sign off on that settlement. And they can have trouble kind of controlling that large number of clients and getting buy-in for all of them to sign off on it. Because what will happen is 50% of them will agree to sign off on it. And then that sets a floor for all the others who then demand more later on. And so the employer is always hesitant to agree to settle a percentage of the claims early and then continue to litigate the others, knowing that they're likely setting a settlement floor going forward.
Oh, interesting. Okay, so it sort of creates a situation where it disincentivizes the employer to actually settle if that arises.
I think it certainly can, based on the economics of having to mediate all of them and, potentially setting a settlement floor going forward for the unsettled cases.
Interesting. Well, then what are your views on things like bellwether cases and batching and those sorts of processes that are designed to sort of get past the mediation phase, but get into merits without having to try all the individual cases?
So I would be a proponent of bellwether cases, especially for employers, because I think it allows you to litigate the case. It controls the discovery. It limits it. And if you think you've got, meritorious arguments, it allows you to test those out without incurring, a significant amount of expense or having to litigate, 50 or 100 arbitrations all at once, which can be very expensive. So I think that's the kind of the economic way to litigate mass arbitrations is to select some bellwether cases. And I've had proposals where, we select 5 claimants and the other side selects 5 claimants. And then we try those 10 arbitrations as the bellwethers and then stay the others pending the outcomes of those. Now, but I've also had where the arbitration agreements don't call for bellwether cases. Most of the time, I'll find plaintiffs' counsel won't agree to bellwether cases. They want to try them all at once to put the economic pressure on the employer to settle.
Got it. How about batching?
My understanding of batching is when let's say you have 100 arbitrations, you put them in batches of 10, and they would kind of progress along different tracks. Whereas grouping is when you agree to have one arbitrator, oversee or try 2 to 3 or 4 arbitrations together. They're still individual arbitrations, but the evidence and the arguments are presented to that arbitrator all at the same hearing and all at the same time. I think I would be more in favor of the bellwether cases as opposed to batching. I think batching can obviously slow the cases down, make it more manageable. I think if you don't batch the cases, you will kind of ultimately with the scheduling orders that you're agreeing to with the other side, you're going to end up with scheduling orders that amount to batching so that you don't have all of the deadlines overlapping and all of the hearing dates overlapping as well.
Yeah, no, that makes a lot of sense. And I think that's why, it's funny. Some of the procedures require bellwethers, others require batching, but one in particular leaves it wide open to the parties to decide based on the facts of each case and to the process arbitrator. And I think that's precisely why, right? Because you can see these instances where having bellwethers might make a lot of sense. You can also see an instance where, if there were a lot of different issues, but some of those issues were common to certain groups, you could batch, you could group, but I think leaving it open probably makes the most sense in certain instances. Well, let's shift gears then and talk a bit about drafting considerations, because I think this is one where, at least for someone like me who drafts a lot of arbitration clauses, this has been an evolving sort of battleground where it's a bit of a chess match with the claimants. What do you think respondents should consider when they're drafting arbitration clauses that involve mass claims or could involve mass claims?
Well, I mean, the number one consideration is understanding the administrating body and their rules and their fee structure, right? Whether it's the AAA, JAMS, or some other provider, that to me is the driving consideration. And then that consideration and then applying it to the circumstances of that particular client or employer. How many employees do you have? What are the most likely claims that are, going to be brought by the individuals that are entering into the arbitration agreements? That to me is the starting point.
And do you have certain seats that you like or certain seats that you avoid?
No, I don't think so. And typically, the the seat that we choose is where the employment took place. And so, and there's actually been some cases out there that you can't just have, if you choose a locale in which the employee did not work, the arbitrator won't honor that seat. And so, for instance, in many of the cases that I litigated in Puerto Rico, there was challenge to, do we have the arbitration? Is it held in Puerto Rico or can it be held somewhere else? For the large percentage of those, most of the arbitrators did agree that it had to be held in Puerto Rico because that's where the work was performed and that's where the contract was entered into. On a handful of those cases, we had it in other locales, either where the employer was located or the claimant currently lived.
Got it. That makes a lot of sense. And I think, some of the consumer rules do the same thing. Now, one of the things that's really interesting about this area too is the fact that it is evolving really quickly, right? I mean, you see a lot of changes both in the rules and particularly in the case law coming out of various circuits. What tips would you offer to respondents or really companies to ensure that their clauses remain current and appropriate for what they're trying to accomplish?
I think that the recommendations that I would have are one, to review your clauses annually or maybe even every 6 months and review them against the AAA or JAMS or other provider rules, so that, because the rules are changing rapidly. And I think both the AAA and JAMS have made significant changes in the rules both in 2024 and in 2025. I think the other thing that you've got to do is track the case law developments on arbitration clause enforceability, particularly enforceability around class waivers, to make sure that those class waivers are going to remain valid despite changes in the law. And I think you need to update your templates when providers change the fee schedules or their procedural rules as well.
Yeah, those are really great tips. And I would just definitely reiterate, it makes sense whether it's 6 months, whether it's a year, 9 months, whatever schedule the company chooses, just come up with something that's rational for your program, stick to it, follow it, and just make sure that you keep with that, because I think there are other procedural benefits as well to sticking to a fixed schedule that can be valuable if you ever have to defend one of these things in court.
Just to add to that, JP, one of the issues I see a lot of my clients bump into too is because they've had employees who've been employed for long periods of time who might have entered into arbitration agreements, 10, 15 years ago, and those agreements have evolved over time. And so they have multiple variations of arbitration agreements applicable to their employee base and to their former employees. That's not a great situation to be in for a number of reasons. And so the other thing I would recommend too is it can make a lot of sense to implement new agreements across your workforce based, once you've reviewed them and made determinations on the provisions you want to include in those, so that you don't have a patchwork of agreements that you're trying to enforce when a claim is brought.
Yeah, that's absolutely right. And I can tell you anecdotally, I have been called by various people that I work with to say like, hey, do you have a copy of the 1980, AAA employment rules? Those types of things that come up when companies don't do that. And it always makes me laugh, because then you're reaching out to the institution to say like, hey, I've got someone who needs a copy of these, and you get something that comes back in courier type font from, when someone physically printed something up or typed something up. Just a tip on that too. It's a really good idea if you're going to institute new agreements, whether it be the employment context, whether it be terms of use, anything where these types of mass claims can arise, to make sure that you're also checking the case law on how to properly notify the people that are subject to those and how you have to give proper notice, because that is something that courts have taken a lot of issue with. I think probably less so in the employment context, because I think there's more of a requirement to directly approach the employees, but certainly with consumers, terms of use, things of that nature, if you don't properly notify the people that are going to be subject to those arbitration clauses, they can oftentimes be invalidated on that basis. More of a procedural due process thing. So just something to keep in mind as well. Well, Brian, this has been great. Thank you so much. It's really wonderful to hear the perspective of the respondent and how companies look at these things, because it really closes the loop on everything we've been discussing as part of the miniseries. So thank you for offering that, and we will definitely have you back in the future to talk about some of the updates, because I suspect the way that this is evolving, there'll be more to discuss within a year. So that will conclude our discussion of mass arbitration from the respondent's perspective. I want to thank our guest, Brian Patterson, for sharing his views on mass arbitration, and I want to thank you, the audience, for listening. You should feel free to reach out to Bracewell today about today's podcast with any questions you might have, as well as to Brian directly, whose information you can find on the Bracewell website. And we look forward to having you tune in for future episodes in our Arbitration Acumen series.
Thank you for listening to this episode of Arbitration Acumen. We hope you found it insightful and informative, and we encourage you to share it with your colleagues if you did. You can reach out to any of our speakers by contacting them directly or by emailing arbitrationacumen@bracewell.com. We welcome any questions or suggestions you might have for future episodes. And please subscribe to our podcast channel to stay up to date with our latest content.